In the last video, we have left the very subject matter of will unfinished. So now we'll start from there. So regarding that subject matter of will, an heirless Muslim can bequest his entire property. A Muslim who has only his wife as an heir can bequest the entire property minus the share of the wife as it was decided in the leading case Muhammad Hussain versus Asia Bai in 1935 by the Bombay High Court. So also in the another leading case Damodar versus Sahaja Bibi in 1989 by the Bombay High Court. So also if a Muslim had married or got his marriage registered under the Special Marriage Act 1954, then Muslim law of succession does not apply to him. He is governed by the Succession Act 1925 and therefore he can bequeath his entire property by a will. And now we'll discuss regarding bequest in future and contingent bequest. So regarding that, what exactly we found in Hidayah. So according to Hidayah, a bequest in future is void. So is a contingent bequest. When a Muslim makes a bequest with a condition, then the condition is void and the bequest is valid as per the opinion of Hidayah. And now we'll go to the next one, bequest for pious purposes. So regarding that, a Muslim can bequest in four different kinds regarding pious purposes. So the first one, a Muslim can bequest by will regarding Hajj or pilgrimage, which is a pious purpose. So also he can bequest his property for charity given on the day of breaking fast or sacrifices, as it is referring to the very occasion of Eid or Eid al-Juha. And the third pious purpose for which a Muslim can bequest his property, that is bequest for the poor or for building a mosque or a bridge or an inn, and all these were found mentioned by Tyabji in his work on Islamic law. So these are the bequest made for pious purposes. And now we'll go to the next, that is regarding the very purpose and how it was found in the leading case Abdul and Tumar in 1884 by the Bombay High Court, and as it was found mentioned as when a bequest violates the one-third rule and some of the heirs consent to it, while others do not. The bequest is payable out of the shares of the consenting heirs only. So, under Muslim law, a bequest to a person not in existence at the time of the tester's death is void. However, Muslim law permits bequest to be made to a child in the womb, provided it is born within 6 months of the death of the tester, as it was mentioned by Professor Baillie in his Digest of Islamic Law in Volume 2. And now we'll go to bequest for heirs. So, a legacy can be made to any person, man or woman, adult or minor, Muslim or non-Muslim. A bequest can also be made for a religious or charitable object which is not opposed to Islam. Thus, a Muslim cannot lawfully make a bequest for a building, a Jewish synagogue, or a Christian church, and the Muslim authorities lay down that no bequest can be made to an heir unless the other heirs consent to it after the death of the tester under the Hanafi law, or at any time under Shia law, as it was held in the leading case Nanis versus Sikh in 1987 by the Karnataka High Court. So, it is not necessary that all heirs should consent. A single heir may consent as to bind his share, as it was held in the leading case Ghulam Muhammad versus Ghulam Hussain in 1932 by the Privy Council. So also it was agreed that the consent of the heirs may be expressed or implied, but silence cannot amount to consent, as it was decided in the leading case Ijul versus Chairman District Kacheri in 1956 by the Nagpur High Court. So now we'll go to regarding construction of wills and the very views expressed by Tyabji. So regarding construction of will, as we found, as it was mentioned by Tyabji, the general rule of governing the construction of will is that a Muslim will is to be become construct in accordance with the rule of construction of the will laid down in Muslim law. The language used by the tester and the surrounding circumstances, it also a general rule of construction of wills that unless a different intention appears, a will speaks from the death of the tester and the bequest contained in it take effect accordingly. It is a universal rule of construction of wills that the courts try to give effect as far as possible to the intention of the tester, where a tester used such ambiguous language that its construction is not possible by giving usual meaning to the words used, then it is left to the heirs to give it whatever interpretation they want. So, this is how it was expressed by byTyabji regarding construction of a will by a Muslim. And now we'll go to revocation. And that revocation of wills, as it was mentioned by byTyabji, and regarding revocation of wills, there are two kinds of revocation. One is express revocation, and the second one is implied revocation. So, revocation of the will as it is expressed by byTyabji, just as in other systems of law, so under Muslim law, a tester may revoke his will or any part of it at any time, either expressly or by implication. Similarly, a tester is also free to make any addition to his will. But if the addition to the subject of the bequest is such that the subject of the bequest cannot be delivered with the addition, then the bequest stands revoked. And in our next video, we would discuss the two different forms of revocation of will by a Muslim. One is express revocation, and the second one is implied revocation. And these two kinds of revocations, as we found in detail, it was mentioned by Professor Baillie in his Digest of Islamic Law in Volume 1, and also by Baillie Amir Ali in his Volume 1, so also Professor Baillie in his Digest of Islamic Law, Volume 2, and all these we'll discuss in our upcoming videos, which would discuss express revocation, implied revocation, so also the most important kind of will, that is mar'ul maut or death illness will. And it was also found in detail mentioned in Baillie's Digest in Islamic Law, Volume 1, Volume 2, and Amir Ali's Volume 1. So, also certain leading cases that we will discuss in detail in our upcoming video regarding Wassiyyat.